I'm Faye Caldwell. I am a lawyer. I'm going to ask you not to hold that against me. I know what lawyers are like in this world, but trust me, I'm here for you. What I want to focus on today, and it's going to be pretty dense, is the crazy morass of state marijuana laws and really helping employers deal with what do I do next. So that's me. If you have questions, you're welcome to email me. I do answer my own email. My malpractice attorneys make me say this. We won't focus on this. They do. They actually make me say that. So let's talk first about what happens in the U.S. We're going to have a little bit of a nod to Canada and Mexico, but really we're going to start. We have plenty to talk about here. So let me give a brief. Let's set the stage for us of where we're at today. 31 states plus D.C. plus two U.S. territories have passed comprehensive medical marijuana law, okay? We're going to get into what that looks like, but that generally means that they have decriminalized the possession of certain amounts of it at the state level. And that'll be an important distinction. Additionally, 15 states who do not have comprehensive medical marijuana law, with the exception of one, also have passed CBD laws, and we're going to talk about that a little bit. Putting together 46 states out of 50 who have some form of legalized cannabis in some form, no matter how small. Yes, there are 4 states at the bottom that not so far. Idaho, and then sort of the Midwest, South Dakota, Nebraska, and Kansas. Everybody else has a little bit. Then we have 9 states plus 1 U.S. territory have recreational. For those of you who haven't kept up, in the most recent time, the Commonwealth of the Northern Mariana Islands has just legalized medical marijuana. That's your trivia for the day. So this is all about what the states have done, okay? And we're going to talk about these, but let's talk about some little things to keep. You notice I'm very, very purposeful. I'm talking about states. I am not talking about the federal government. We'll get to that. If you're concerned for your companies when it comes to federal testing and what the advent of medical marijuana means to you, the answer is it means nothing. If you're talking about federal testing, all of what I'm going to talk about today is absolutely inapplicable. So I'm only talking what we might call non-regulated testing, okay? So that's an important facet. Just so you know, Mexico has medical marijuana, and I think anyone who's alive on the planet knows that just recently Canada went to marijuana. It has. For those of you who are interested in Texas, we have one of the most restrictive laws, but we do count. If you have intractable epilepsy, which has failed 2 different medicational syndromes, you can use CBD oil as long as it doesn't contain over 0.5% THC. Seen as one of the most restrictive, but yes, Texas has something. What is most interesting, and people have not yet realized, is that, however, in the GOP platform this year, which has just came out, they have asked for passing of the Cannabis Compassionate Act. I believe, at least according to the GOP, that we are on track to at least look pretty closely at medical marijuana. It's only a signal. It's not anything legislative, but it's interesting, and maybe looks at a policy shift in a very, very conservative state like Texas. I offer that as an example only because we happen to be sitting in Houston, Texas. The future is very, very changes every day. I never make one of these speeches that I'm not constantly updating it because marijuana has changed so dramatically. So all I can tell you is this is today. I make no promises about tomorrow. Okay, so here's your list of states. As you heard, DISA will make the slides available to you. You don't have to write anything in. These are the states and the years they went. You see some patterns, you see some trends. The laws are constantly changing, and by the way, comprehensive medical marijuana in one state is not the same as comprehensive medical marijuana in another state. Each state has its own system, let's call it, of how they handle it, the extent they handle it. There is lots of things that are changing, and by the way, they're totally inconsistent. They don't match each other. There's lots behind this. What are the program requirements? Physicians, who can recommend it? How much can you possess? Distribution, reciprocity, who can qualify, qualifying conditions. So this is a list of ones that have comprehensive, but they are no means the same. Nevada has nothing the same as marijuana, as Montana, for example. It just doesn't. And so for employers in your state, each state stands on its own when you start looking at that. Okay? There are 9 states right now, plus the Marianas Islands, who have recreational marijuana, just if it wasn't complex enough to have medical. Again, amounts will vary. How much can people possess? Sadly enough, what employment protections may come out of this? We're going to get into that, but this sort of gives you an overview of how it is. Here's your low THC, high CBD law. So let's stop here a moment and talk, what do I mean? CBD oil is a product of the cannabis plant. Cannabidiol for those who want the geeky stuff. What this means, and it is not psychoactive. Somebody who is taking pure CBD oil is not going to have any psychoactive effects. They're not going to get high. However, it is regulated because, remember, the cannabis plant is Schedule I in this country. So these states have allowed it, but they have very, very different things, and you have to be careful. You have to say, for example, in Georgia, you can have 5% of it be THC. Yeah, that's the active ingredient. Told you about Texas, which is 0.5%. So they're very, very different. And CBD levels, which are sort of seen as fairly safe, you know, because they're not so active, it depends what's in it. So let's talk, and I'll digress a moment and say what happens to someone who claims, I took CBD oil and I didn't pass my drug test. Anyone want to tell me how many people have ever heard that from a donor? Yeah, that's what I thought. Okay, so the answer is, why is that? Is there a lab problem? The answer is no. I mean, while everyone's human, the answer is CBD oil in and of itself will not test positive because the confirmation test is hunting for THC and THCA. Okay? The active ingredients, and then when you confirm to THCE, the metabolite. But it's a very much of a buyer beware world out there. So you've bought off the internet that your donor has a very, very lovely batch of THC, which they sell now as CBD oil. Yeah, that's exactly what I'm talking about, is what's actually in that CBD oil may or may not be THC. So that is the most common reason, if they go back and analyze the cannabidiol, that they may in fact have it. But it also is weight. You get a heavy user of 5%, who knows? Okay? But it's not the CBD oil that is causing it. There's no reported case of that happening. And I know there's a lot of questions around CBD oil because of people's claims, but we'll work on it. So here's a map. You're going to see the 4 that have nothing, and you work through it. So what's happening? Okay, and I'm not going to do every year back because it's crazy. But you look at medical marijuana, past legislation, I'm only talking 2017, 2018. You look at all the ones that passed legislation for it, Oklahoma, West Virginia, Utah, introduced in 12 states. Typically, I'll tell you, when we watch legislative trends, it tends to fail for a couple times before it in fact passes. And it's on 2 ballot initiatives for medical marijuana. In Missouri, we have 3 different versions just so people can do their sort of deli selection of which version they would like, and Utah, which is Proposition 2. If you look at recreational marijuana, we have Vermont, which passed in this year, and then of course we have 1 U.S. territory, and I marked down Canada because for those employers in this room who deal with Canada, it's just a big deal. It's a big deal, and each province is different. Introduced in 20 different states. That tells you how broad-based it is. And New Jersey and New York are seen as some of the most likely next battlegrounds, and it's on the ballot in two states, Michigan and North Dakota. New York didn't get there in time, but there is some thought pattern that that's going to go. And New Jersey, it's off track at this moment, so I don't think it's going to make it. But it's making its way through the legislature, and you have to watch it. It may not be a voter initiative, so it wouldn't necessarily be on a ballot. It could be passing by legislative means. Okay, I promise that the day that no one asks me about DOT testing, I will stop this slide. But I'm going back to what I said at the beginning, and those who listened to Dr. Donna Smith's speech, you heard her say it. If you're talking about regulated testing at the federal level, you don't have to be worried at all. Federal law controls. Nobody, when the MRO calls and it's a federal test, there is no talk. There is the discussion, you test positive for marijuana, where this conversation is really over, other than are you taking Marinol or a prescription drug containing marijuana, of which there are only a couple that would be, and those are synthetic, with the exception of, we'll get to one that just passed. In this one, in 2018, the FDA just approved the first drug derived from the marijuana plant for 2 types of severe childhood epilepsy. It is less than 0.1% THC. It's mostly CBD oil. But it's there. It shows that there's something happening here on the federal side. So the big question, and I know a lot of you asked ahead of time, of what does this mean? What does this mean for the future? We understand today's picture, but what's the future? So we have a new administration as of 2017. They were a little different than the previous administration, but it's still classified as a Schedule I drug. General Sessions had an anti-marijuana policy, but we have something called the Rohrabacher-Blumenauer Amendment, because the question that comes up most is, why are we talking about state medical marijuana if it's federally illegal? Wouldn't that be easy for everybody if we could just say it's federally illegal? We are really done here. Politics is never as easy as that. Although it's absolutely true it's federally illegal. And so you think, so why doesn't the Department of Justice go in and shut down those medical marijuana facilities in those 31 states that have it? They could, just to work legally they could. But there is a rider on your federal budget that says that the Department of Justice has no money, can spend $0 pursuing enforcement of marijuana provisions in states that have medical or recreational marijuana. So it's a weird thing. It's like it's illegal, but we're not going to enforce it. That is exactly the situation we have in America today, and as long as that goes on, that will continue to be there. It is now currently passed through December of this year. Every time you hear about the budget issues and are we going to shut down the government, this amendment rides along with that. So we'll see what happens. I'll tell you that from the policy point of view, there's been a lot of movement on the federal, more a dozen bills at the federal level that would look into it. In 2016, there was talk about rescheduling. The FDA did not do that. But there's a number of things. So it's a very much of watch this space, which is, I guess, where we started out, right? It's true today. We'll see what happens. But as of this moment, federally illegal, not enforced with non-regulated testing for those states that have medical marijuana or recreational marijuana. That's sort of the, anyone who has questions about that, I can explain all about preemption, but that's sort of it in a nutshell. So let's talk about what's happening. What's happening out there? What's the trends? And then don't worry, we're going to get into the individual states and you can see how you actually handle that. But this sort of sets the stage for us of where we're going. So, depending on which side of the fence you're on this one of the trends that is most divisive is, what does it do for the workplace? What does it do for you as an employer to come out and say, how do I manage this? Do I have to accommodate someone's off-duty use of marijuana? Yeah, sometimes. On a wristband, the answer is yes. And notice I said that very carefully. Off-duty use. So, but they were going to go through the explicit employment protections, what carve-outs there might be in various states. But there certainly is the trend. And many states that have medical marijuana, in some cases that have recreational, have started to pass bills or start to look at bills that would provide explicit employment protection to their already existing marijuana laws. Nevada in 2014 added basically an accommodation. There's probably more protections, and this is really made up, I don't apply this, but schools, landlords, all sorts of things, they're getting broader based protection basically in life, not just the workplace. Expansion of programs, one of the biggest issues is what can you use it for? Medical marijuana is kind of a weird animal. It's medical, which would seem a physician would kind of determine what makes sense. But guess what? In most states, though this is changing, the legislature decides whether you can have medical marijuana, not lawyers, not doctors. So what happens? All right, so you heard me tell you in Texas, you have to have epilepsy, to have CBD oil evenly, and regardless of whether your doctor thinks it'd be helpful for something else, you can't use it. And that has been the historical method, putting aside California. But now we're going to either expanding the qualifying conditions. What does that look like? That looks like opioid disorder. That looks like PTSD. You can see some sort of answer. So qualifying conditions are being added by the state health departments and the state legislatures. And physician requirements are changing. Does it really have to be a physician? Could it be a physician's assistant? Can they just determine it on their own? All of these are changing and expanding. No one's contracting on this one. It's all expanding. The other thing that's interesting, and I don't know really where it goes, and it certainly doesn't add much for the workforce, is the idea that it really, how are we going to ingest it? So smoking and vaping is one of the most common methods, but many states have restricted it to oils. So they must take in oils. What advantage does that provide? Well, one, you can do dosage better because there's no dosing when you're smoking. But it also sort of controls the method of ingestion. So someone who has leaf cannabis isn't within the medical marijuana program. So that is another thing, and it's sort of, I think, a balancing of, yeah, we'll give you your medical marijuana, but we're not going to give you smoked marijuana. Let me assure you, if it's after the fact testing, there's really not much method to sort of figuring out how they ingested it. Impairment under the driving, you'd think that that'd be a kind of standard one. Not so much. There is no current per se limit. Think of alcohol. There is no per se limit in most states. There's 2 states, and we have it, but very, very few. There's no consensus on the limits. And of course, I'm talking in blood. I'm not talking in urine, oral fluid, or hair for workplace testing. That'll develop with time, although I will tell you it's going to be a difficult thing because methods of amount of ingestion in marijuana really depends on how they take it in. If you smoke it, it's one level. If you ingest it in edibles, it's another, as far as how the body reacts to it. 8 states, under the recreational marijuana, have no employment protection. Okay? You notice I said 8. There's 9. And that's because there's no medical protection for recreational use, if you follow me. There is one state. How many people in here have employees in the state of Maine? I'm sorry. We're going to be talking a lot about Maine today. But in its first state legislature passed bill, it gave what appeared to be explicit employment protection for those people who engage in recreational marijuana. How crazy is that? Okay? But it is. And there is one on the book, well, there's one in talk. It's not there yet. New Jersey is considering the same thing. The reason I say Maine is Maine has come up in their most recent iteration. They don't explicitly say it, but they don't also explicitly say there's no employment protection. But we're going to have to deal with that as well. But it's very, very confusing. Okay? That's our backdrop for how we're going to now deal with your world every day in dealing with medical marijuana. So let's talk about the protections. And I'm really now going to focus on employment. There's lots of interesting things to talk about in marijuana, but this is where I think our focus is going to be. So what do you have to consider when you look at this? Now, these have medical marijuana laws, right? I mean, they have a law, but is that all you have to look at? I wish it was that easy. You have to look at the state discrimination laws. You have to look at ADA. I'm talking on a state level now, not a federal level. Remember, that one's not allowed, but on a state level. What does it look like, the unemployment benefits? Can you terminate someone for having, can you deny unemployment benefits if they had a medical marijuana card? Maybe, probably not, maybe, because it's not willful. What are the drug-free workplace laws in the state? How does that interact with the federal drug-free workplace law? What is Family Medical Leave Act? What does it do if you're a caregiver and not the actual user? All of these interplay, so I'm going to advise you, and we're going to talk a lot about the law, but in your individual circumstance, you're going to have to look to your legal department to look at your individual employees and not just consider the medical marijuana law or the recreational marijuana law as applicable, but kind of all of this big bolus of what are you going to do. But let's see if we can break it down and sort of see what the trends are and kind of lump these together. So we have 3 categories based on what we know right now. One is you got 13 states, and we're talking medical, so out of the 31, that have explicit employment protections. And they vary, just so we're clear. It's not the same in every state, but there's something that an employer needs to say, hey, I better pay attention to this in the actual medical marijuana law itself. There's 7 states that there's explicitly no protections. How do we know that? Well, one is, in a couple states, the statute itself says it, or we have a state Supreme Court saying. You're not insulated from everything, and this is all I can tell you is today. This is a very, very changing world, as we're going to see. And the current trend is adding protections. Just let you know, that's the trend. And then we've got 11 states in D.C. that there's nothing explicit for, there's nothing explicit against. It's just maybe. I will tell you that I've been in this industry way too long as a lawyer, and I can remember when I started, back at roughly the time that federal drug testing started, there was no law on drug testing. In every state that I would find a client sued, I would have to go in and develop the law. And now it's kind of clear, duties, employers and stuff, not everywhere, but we're in the exact same spot with medical marijuana and recreational marijuana that most states have not had the opportunity to have the courts look at these legislative and then apply them to individual facts. So we're where we're at today, and all we can say is it's changing, and we're going to talk about some cases we're looking at, and we're going to talk about some trends of what you can possibly do in light of this ever-changing world. Okay, 2017 was a watershed year in my world. Why? Before that, courts consistently found no duty to accommodate. The employers didn't have to accept a medical marijuana card. I will also tell you, because these are handfuls of cases, right, that those cases were all in states that had no explicit protection. And in 2017, we started to get new court decisions on some of the new statutes. So, pre-17 cases, and if anyone ever wants these, just let me know. We have them all. No duty to accommodate. There was no court decision at all construing explicit. This is a changing law world, and it takes a while for courts to get up and do it. So what happened in 2017, 2018? And we finally started to get states that had explicit employment protections. And they upheld the action in favor of the employee and found that the employer was required to accommodate. Okay? There were 2 decisions in states with unclear provisions where they weren't. And in one case, they found for the employee using the state's disability law. Another, they found that the federal court found it illegal. So it's very much looking beyond and looking to everything that you've got. There's other decisions out there, but these are the ones most germane that we have it. So you have the 2017 ones, and this will be in your slides that DISA has kindly offered to make available to everyone, that we're not going to go over, but these are the ones that kind of got people a little revved up. Yeah, we're going to be okay. I would have to tell you, I was a little bit of the Cassandra of the room going, need to wait, need to wait. And whether you like it or not, I'm just here to tell you what the law is. And now we found 3 states, Connecticut, Rhode Island, and Massachusetts, that found they had protection. And if you ever want to read and are really interested in the geekiness of federal law and why federal law may not preempt everything, read this case, the Knopfsinger case. It goes through an exhaustive analysis of why the Federal Drug-Free Workplace Act does not stop an employer in Connecticut having to accommodate medical marijuana use. And we can talk about that. But these are ones that where it's explicit, I will tell you, it is my belief, based on what we're having, that yes, we will continue to see this trend. So we really need to be in on the beginning before the law is passed, before we don't. And that is definitely the trend. There is one decision without explicit that found in favor of it. It's also a state, I'll tell you, that is considering adding explicit protection. So that's sort of the downside. These two, we're watching, you know? This is one where it's a difference, you know, where you're seeing the differences in these decisions, New Jersey and Montana. They're slowly but surely coming out and finding out. This one you didn't have to. And they've also found it in Montana. What's interesting is don't rely too much on any one case. It's in a different state. Now, I put this because you're going to see both timing trends and decision trends on the same issue. So we have the one in silence, employer not required to accommodate off-duty use. This is in Washington State, 2011, before the big wave of medical marijuana. Silence in 2017, employers absolutely required to accommodate. Whether the federal law preempts state medical marijuana, so there's no duty, regardless of what the state says. Okay? So we have Oregon in one, which was silent. And then we come down to these 3. They said, nope, not preempted. So be aware. And so I can't tell you, for example, what any individual state will go to. Don't worry, we're going to get to risk of handling. Well, I promise you that. But it is difficult, and you have to look at whether the Federal Drug-Free Workplace Act, which I think a lot of people have relied upon. The answer is maybe and maybe not. The idea, I will tell you on the maybe not, the one that found it didn't preempt, is the idea, as we all know, that the Federal Drug-Free Act, in fact, does not mandate drug testing. You have to encourage it, but there's no requirements. And that's what the state court looked at in that state to look at it. I want to focus. No, you're right. Okay. This is a generality. And just as we can break down the explicits, we can break them down by a number of standards. Okay? These are explicit. These are the 13 I told you about. And they come differently. So some of them have that basically your basic urine, hair, or oral fluid test, simply having a positive drug test is not enough. Okay? That's a discriminatory statute. What leaves open for it, and I think that you're going to hear more about this, is what does it look if you also have reasonable suspicion? What happens if you have effects of impairment that are documented? These clearly would support, in my mind, the 4 states that have the positive drug test language. If you have something else in addition, that's going to help you out with the idea they're impaired on the job, which no one allows. You never have to let anyone work impaired or under the influence or use on the job. The question, as we all know, the sticky wicket is, how do you tell if they're impaired? So things like reasonable suspicion, probable cause, those are going to go a long way towards helping. We also have 3 states that have specified safety-sensitive positions with if you don't have to have them performed, they have certain amounts of THC in blood. Pennsylvania and West Virginia. Now, I will tell you the trouble with this. How many people here are doing workplace testing in blood? Yeah, that's what I thought. Not a 1. Because this is the only one you can do. It's on there, and I think the legislators believed that they were trying to help out employers, not understanding that that's just not the way we do it. But it's on the books, and it's the biggest nod I can tell you to the idea of safety sensitive. Here's the sad part, folks, is how many people would like to control medical marijuana or marijuana because of the position that the employee holds, i.e. safety sensitive? Yeah. The law doesn't support that. Think about alcohol. You let them drink alcohol off duty, right? Well, they can then also, if there's protection in a state you're out, you can have them do that, but they can't work impaired. So the real goal is, are they impaired, not whether they have a positive urine metabolite test. And then 2 states treat it as a disability. So it's an accommodation issue. So, and we're watching a pending lawsuit. But these are sort of to give you an idea of the explicit protections can really vary, and they look different in different states. Okay. I want to talk about Oklahoma for a moment because it just passed. And at least being from Houston, Texas, and being involved in the oil and gas industry, it's kind of near and dear to our hearts. This, I have to tell you, I think caught most people by surprise. Came out of the legislature, and it was done. Okay? I mean, Oklahoma, who'd have thought Oklahoma would go for a broad-based medical marijuana law that doesn't have any qualifying conditions? You can have a physician go, and by the way, if they have a card, you got to accommodate them. Who'd have thunk it? But that's where we're at today. Now, you've seen, this is the actual language from the statute. Okay? And I want to talk and break this down for a moment. This is totally untested. There's no case law on this. It just went into effect a couple months ago. Okay? Unless a failure to do so would cause an employer to imminently lose a monetary or licensing-related benefit under federal law or regulations. That's the huge caveat, right? So I can not accommodate if that happens, right? But what does that actually mean? We're going to wait for courts to find that out. I mean, seriously. I mean, so we have, I first went to the Federal Drug-Free Workplace. It's an automatic way to go. That's a federal law. Okay, I got one case in the country that says that's no good. I got one case that says it's good. How would an Oklahoma court do? I don't know. What does imminently mean? I don't know. This has never been tested. I will tell you this is new language. No other statute has this in exactly this format. So it's going to be. So what you would need to do, and I invite everyone, because I think this is, I mean, I'm a big safety person, so I'd love to make sure we don't have people using marijuana in the workforce. But you have to sort of take the federal law or regulation you're relying upon, and that could vary according to your industry, and see whether you can make a case under this. Now, I will also tell you also whether your corporation's legal department wants you to make a case under this. This is risk. It's unfounded risk, but it's there. It's there. I just don't know, as we sit here today, what that's going to be. But otherwise, it's clear you can't discriminate. Any term or condition of employment based on their status as a medical marijuana license holder. But they can take action. Remember, you never have to let them use in the workplace or be impaired in the workplace. And that is universal across all of them. Okay? You never have to do that. But understand that a workplace drug test isn't going to tell you any of those answers when it has. So this is sort of Oklahoma, and you can see how it perhaps raises more questions than it answers. I predict in 5 years, we may have some stuff around it, and maybe less. But right now, this is the legislation. And we're going to end up having to see, and frankly, companies' tolerance for risk of what you want to do. So it's a tough one. Okay, that's it. Now we have these with explicitly no at this moment. Your California, Colorado, Florida, Montana, Ohio, Oregon, and Washington. And then in the states, we also have, two are by statute, and the others are by Supreme Court decisions. How long these hold will be interesting. Several of these states have introduced legislation to try to change that. To give you an idea, and you'll be able to take this, we're not going to talk much about it. This is the explicitly no protection language. What I wish that most states would do as best they could, I would like that, so that we are not left sort of knowing which way you want to go. But these are both fairly recent, 2-year-old statutes that have made it very, very clear. These were constitutional amendments, I think, yes. And then Ohio was signed by the governor. Okay. We're going to go through briefly. These are the states you just don't know about. You don't have any idea. You need to look at the state disability law. And the laws are vague. Most of these have not had any challenges that have made their way through the courts that I've been able to find. And my group tends to take a pretty close look at what's happening. So there's some guidance and stuff. But right now, there's nothing adverse against it. But you have to keep track. So this is where we're at. Exploitation protection, we're going to have those. These are some that are seeking to add, and those with unclear are sort of watching the trends. I do not see any trends. There's outliers. I don't see any trends towards not adding protections. No one's going back. We've got some lawsuits we're watching. We'll keep everyone posted on those. Sort of what's happening in those world, and these are in progress right now to give you an idea of how fluid it is. So I've now told you, and I've scared you probably to death, of what in the world do I do with this? Don't worry, don't worry. Let's talk strategies. So let's talk about the questions that, as an employer, I'm going to suggest that you ask yourself and consult your legal counsel on. One is, do I have to accommodate marijuana usage? What laws apply? How do I handle marijuana positive drug tests? Okay, so what do we do to avoid litigation? Now I'm going to give you my bias right up front. I represent only companies. I represent employers like you, and I represent other people in drug testing space. I don't know any of them that really want to go out and buy litigation. They wish to avoid litigation. So I tend to, but I'm telling you, if your company wants to go, we're going to go hardcore and we're going to challenge that in court, go right ahead. That's not where I'm going to be going. I'm going to be talking about avoiding. Okay? So you have to know your workforce. What are the first questions I ask my clients when they want to say, what do I have to do? Where is your workforce? Where do they live? Where do they work? Those could be two different things. What's their position? What are your safety issues? Do you have employees in multi-states? Do you have employees that cross states? You have to know those factors. That's what's going to make the difference to you of what happens, and that's what's going to drive your decision-making process. So if you want to help yourself out, these are the information you need to gather. You have to know the law. You have to take your states. You know, if you have 5 states, take those states. Find out what the law is in those states and what your obligation as an employer is. You have to decide the policy. So let's talk about differences. Okay, I personally, but you know, I'm not the employer, likes to say if you should enforce marijuana restrictions every time you can. Okay, that's fake, because I believe in safety, and I'm not convinced. So I believe that you should only accommodate in states you have to accommodate in, or you think you have to. But that's me. Perhaps your employer has all office staff. Okay? And you decide, no, it is not worth it to me, I don't. That is a policy decision. Not one I advocate, but you have to look. On the other hand, if you have crane operators, that's just a different dynamic. You want to do everything you can. But you need to decide your policy, and you need to be clear and consistent, because I'm a firm believer, most donors are negative. Come on. You know, we test lots and lots of people that are negative. You want them to stay negative. You don't want them to inadvertently test positive because they didn't understand your policy. If you're not going to accommodate, let them know that. Perhaps they won't go out and smoke on the weekend. What you don't want, and what does happen, and I hear it a lot, is people going, oh, I thought it was legal in Oregon. I thought I was okay. That's kind of sadness, because you really thought he or she was a good employee. Let them know, no, we're not going to accommodate you. So let's give some examples of what we're going to do. What state law applies, and do I have to accommodate medical marijuana? I'm going to use an example that I get the biggest question about is multi-state issues. How many people have employees who can work in one state and also perhaps work in another state? Okay. Okay. Let me tell you, there is not one single case on this that's yet been published. Okay? There isn't. We haven't gotten that far yet. We have no one. So they live in Connecticut, but they work in Massachusetts. You see all the differences. The best avoidance, and that's all it is to take the most favorable to the employee and apply it. That will avoid the most lawsuits. And you have to decide what your risk tolerance is. Now, you certainly do not have to accommodate, we're clear, if someone's in Canada and then allow them to come home. That's different. They've crossed state borders. But if they work in one state and you've sent them, you have to consider whether or not. But the most restrictive thing, and to avoid litigation, is to look at the most restrictive law and apply that. That is going to keep you out of the most lawsuits. Now, I'm going to tell you, that's a big balancing act. Okay? I got safety. But, this is assuming people are holding cards. Remember, at the end of the day, not that many people have medical marijuana cards. Most of the marijuana positives do not have medical marijuana cards. What do you do when the applicant employer claims medical marijuana cardholder status? Okay? Let me give you the classic example. Is the person tells the medical review officer or tells the DER or tells the hiring applicant, yeah, I tested positive for marijuana, but I have a medical marijuana card. Okay? You need to have a process for that. I'm calling this a decision tree. So, first off, let me be clear. They can have a marijuana card that is expired. Don't assume, there has to be a tree. What's the policy? If it comes to your attention as an employer, and by the way, I recommend it come to your attention as an employer so you can take the right actions and act out of knowledge. You have to get someone to look at that card. Is it a facially valid card? Please don't try to go behind it, but is it expired? Does it look inaccurate? There'll be things. Most states have cards with the exception of California. Little tipper. Laws don't let the employer determine the reason for the card. You want to invoke HIPAA? You do not want to know that they have Crohn's disease. You do not want to know that they have HIV and AIDS. Trust me, you don't need that help. They have a card. A doctor has said they have a card. That's it. Your determination, then the law takes over. And lastly, ensure that the medical information, because this is now arguably medical information, and there can be very restrictive state laws on medical, remains completely separate from disciplinary channels, whether you end up accommodating them or not. Privacy. Let's not buy a privacy problem while we're having it. But use your decision tree, take your policy, at a minimum comply where the state law makes it clear you have to. What happens when the bad thing happens? Someone doesn't like the result. Now I'm going to go a little broader than this. Because I've been asked also to cover a little bit about avoiding strategy, litigation, and drug testing. People make complaints. It's one of the few areas in laboratory testing or human resources where people just don't like the result. I often say when I have my cholesterol checked, and if it needs help, I work with my doctor. This is what we call adversarial testing. No one's happy about a positive drug test. You need to quickly engage legal help. Why do I say that? Call your legal counsel. If someone's making a complaint, you need to gather the facts quickly. And people's memory will never be better than the day you get the complaint or the claim. You need to identify quickly if there's a problem. Folks, humans are involved in this. What happens when you find out that, oops, we didn't pay attention to that? My personal recommendation, because lawsuits are long and hard, and I fight very heavily for my clients when I'm involved in them, and I do it every day. But they're expensive, and they take away attention from your core business work. If something was truly wrong, look at that early. I will tell you, as a lawyer who gets paid by the hour, we love it when people don't look at it early, but that's just not the right thing. You look at it early, you do it. The other thing I'd like to say is, if you find something was done wrong, make a change. It's hard sometimes to say, what I call the lessons learned. Lawsuits and litigation is a very expensive way to have lessons learned, but it doesn't mean that it shouldn't be done, because that's the only way to prevent the next one. The worst thing is when you get the repeating cascade of them. My personal strategy, and this is the Faye Caldwell strategy, is particularly in drug testing, there's no smoke and guns, folks. The testing was done, the documentation was done, the MRO interview is done, the disciplinary action's been done long before you get the claim or the complaint. I will tell you, when I represent a lab client, for example, I give the data pack over. They're entitled to it anyway. It's not going to be magic, and oftentimes we can talk them out of it and explain, no, everything was done right. Or the MRO interview was done and say, yes, we did ask you about this. We did ask you about your marijuana status. No, you didn't provide it. Yes, we did offer you a repeat. I often will say, give it to them. They're going to get it anyway when they file a lawsuit. And sometimes, as long as it doesn't harm your case, cooperate. Okay? Look for early resolution. I'm not a big settler of lawsuits. I got to tell you, that's not my client's strategy. But I file lots of motions, and this is sort of legalese. My goal is to get my clients out as fast as possible, so A, they can quit paying me, and 2, they can go back to their work. You guys have a very busy world to run, and you don't need to be sitting in depositions, gathering documents for me, and basically talking to attorneys. And of course, my other one is I fight like crazy on everything else. So that's sort of the string, and I know that's very fast, but that's sort of where we got. Now, but we're actually going to make this very easy, because I'm, with my co-host, David Porter, I'm doing the next session right here. So if someone has a question or wants to ask me in the 5 minutes, I'm happy to answer.